when you sit here and say that this is a power that's vested in Congress, what you're ultimately saying is that this is a power that is of the people. Remember, and never forget this, Congress is you. These people represent you. You are their bosses. Do not let these people get it twisted. They're retained in action by state legislatures. And the Supreme Court cannot substitute some sort of preference for policy because where there has not yet been action taken by the elected representatives of people, or if there has been action taken by these elected representatives and it's disliked by activists, you can't have the Supreme Court come in and just legislate it. I mean, that's the whole issue. I mean, you even have Rehnquist, William Rehnquist, and then I have a whole bunch of, you get the point from all these progressive activists. I mean, they're actually a little concerned about how this actually affects other cases and it also misrepresented the history of the practice and the attitude towards it. That's another, huge point here. But the privacy right, and this is what I want to touch on, because that Roe versus Wade was ultimately a privacy ruling, right? A right to privacy. And the idea that the determination to have an abortion is considered a right to privacy, that does not have a foundation. There's nothing within the text of the Constitution or the minutes of its creation that has any kind of, there's no support in that for that argument in the Constitution or founding documents. So what they've done with Roe v. Wade is they've expanded it to say that a right to privacy includes whether or not you want to have an abortion. That's also a definition of privacy. That's insane. That is a stretch. That bastardizes the 14th Amendment's whole idea and interpretation of personal liberty. And that's, and the other thing too is that I don't think it's ever been examined. Now, this is me pretending to be a lawyer. I don't think that it's ever been examined whether or not the intent of the drafters of the 14th Amendment actually had the determination to include as a provision of privacy the being able to, or the act of obtaining an abortion. It doesn't make any sense. The 14th Amendment wasn't about the creation of a different, separate, new right. It was about securing existing rights with people who deserved those existing rights. Rights that were already guaranteed by the Constitution. There's no constitutional grounding to that. And it doesn't matter. You should be able to, if you are somebody who's pro-abortion, whether it is for whatever reason, that's something you should be able to acknowledge if we're going to have a discussion and base it in fact. If we can even agree on that point right there, that there isn't a legal founding in that already, and that the right to privacy was bastardized to the point where it actually could threaten other things that affect all of us, then we can't get past that. We're never going to be able to have a debate on it. That's the whole thing.